SJC-11126, Commonwealth versus Buff.
Mr. Kuna, good morning.
Chief Justice Gantz, good morning. Justice Gaziano, Justice Budd, Justice Kafker. My name is John Henry Cunha. I represent FAP Booth. This is a case, as is often in this session, a tragic case. Two people lost their lives. The facts that I'd like to deal with first were that although disputed, I think it's fair to say that the jury could find that my client knocked on the door, bought some marijuana, left. That was agreed upon by both Mr. Booth and the surviving wife. And then he returned. What happened then is disputed, but I'm not so sure that it matters. What the jury could have found is the testimony of the wife is that she opened the door part-way. My client then opened the door the full way, stepped back, and two men came into the apartment. The wife ran into the room and hit a table, falling onto one knee. When she looked up, she saw two men by the couch who were holding guns. She said, actually on cross-examination, that as she was falling, she heard a pop, pop, and the inference is that her husband was shot at that point. Her daughter came running out of the room, and there were two other gunshots, and she was killed as well. The other aspect of the evidence, and that goes to the merger issue, but if I could, I'd like to deal first with the issue regarding whether there was any evidence at all, and I suggest that there was none, that Mr. Booth knew that the other two men were armed.
Are you done with the first one?
No, Judge. I just wanted to sort of I mean, I know you've read it, but...
No, go do your thing.
Yeah. There is no evidence, none, that Mr. Booth knew that the other two men were armed. The trial judge said, well, it's a fair inference in his view. His view was that there was a fair inference that Judith, and we've referred to her by her first name just because her husband and she shared the last name, saw guns as they came in. But there's no evidence of that. Her testimony is that when she looked up, having fallen, she saw guns. That's the first time there's any mention of weapons.
What about the GSR evidence and then also the statements about being armed to do a robbery?
Well, there was no statement about being armed, Judge. There was a statement 2 days prior.
Right? Yeah.
2 days prior, one witness said that Mr. Booth was present when, I believe it was Hyang, said that he wanted to rob a drug dealer.
And there's some hand gesture of some sort or something?
Well, the testimony about that was that, I think it was Hyang, made some gesture as if he were armed. I'm not quite sure what that means. But the person said that he didn't know if Booth was present at the time. So I don't think there's a fair inference can be drawn. There's no evidence that he was present when this gesture was made.
And obviously what you were giving us and what you started with, as you well know, was in the light most favorable to the Commonwealth. And I think you've been, I think your recitation is in the light most favorable to the Commonwealth.
I think that's correct, Judge. I mean, I think that's my obligation, and so that's where I am. So,
Can I just question that a second? Because I'm just looking. Also, according to Fu, 2 nights before this offense, the defendant was present during at least part of a conversation in which Hang had asked Fu to call a drug dealer with his hand in his pocket like he had a gun, prompting Fu to tell him, if you've got a gun, get out of my house. I thought he's present during that.
No, Judge. The testimony was that my client was present during part of that conversation, but he was going in and out of the room, and the witness stated that he did not know if Mr. Booth was present during that aspect of the conversation.
So in the light most favorable to the Commonwealth, if he's present during at least part of the conversation,
Yes, but there's
That's
no
not a-
evidence that he was present during that part of the conversation.
And what do we make of the GSR testimony, Mr. Cronin?
Well, I don't know what to make of that, Judge. First of all, that would be after the fact. And at some point, he came into contact with somebody. There's no evidence that he had a gun. There's no evidence he fired a gun. So at some point, he came into contact with somebody. What the government has suggested, I think, at trial, and maybe in their brief, I don't hold me to that, but certainly at trial, was that there was what I think is speculation, but well, maybe there's an inference to be drawn that he saw the people, the shooters, afterwards, and that there may have been some transfer of GSR. But that does not in any way indicate prior knowledge of a weapon. And certainly that is the government's burden, not to prove that he knew that afterwards that they had weapons, but that he knew before that they had weapons.
so if he's present when two talk about robbing a drug dealer, that's
Yes.
not enough, because
Well,
you tend not to rob drug dealers without weapons.
Well, I don't know, Judge. I would disagree with that. I mean, that's asking.
You're a brave drug dealer robber without a gun, right?
Judge, this was a terrible situation. You had a man who had 3 strokes. He had I don't know how old Judith is, but she makes reference to the fact that her grandchildren's toys were in the room. She says that she threw some things and maybe toys at them, and then a 16-year-old girl. So I don't think that this is a situation, and this also applies to the merger argument, that necessarily you would expect to use a weapon.
So this is ironically unlike Brown that you cite in your other argument, where there was a need
Yes.
to be armed to rob the big guys, as they said in Brown.
Yes. Yeah. I mean, these were helpless people.
Because there are cases that the other side cites where we've said maybe there is an inference in these drug rips that people arm themselves, but you're saying that really is not applicable in this unique situation.
I would say that it's not factually applicable. I would also say, Judge, and this goes to the merger argument, that I think that with all due respect, this is a judicially created evidence. And it basically says that because of what's going to happen, or basically upon proof of the other three elements, you are allowed to draw an inference as to the 4th element without any actual evidence. And I think that violates in re Winship. I just don't think it's constitutionally. I know the cases are there, but I don't see how it passes constitutional muster.
Just to
Yes, Judge.
clarify, isn't it that the Judith didn't know the other intruders, that she only knew Booth, your client?
Yes.
So
Yes.
just in terms of knowing whether or not to come armed, he would be the only person who would know the situation.
Yes, and the government's position, and I think the jury found it, was that he knew there was going to be a home invasion.
He's a scouting party.
Well, whether he's the scouting party or not, I don't, whatever it is,
In the light most favorable
he
of the
opens the
government.
door for them.
Right, no, you've conceded that in the
Yeah.
light most favorable of the government, he
Yeah.
steps aside.
Yep. And so, I think the fair inference is that who these people are had been conveyed to the two who entered, Hyang and Sun. Now, why it happened the way it happened, that there was an almost immediate death, is difficult to understand. But that is the evidence. And as I understand, I think as anybody, and the only fair reading, and this is in the light most favorable to the Commonwealth, is that this whole incident probably took about a minute or 30 seconds. She says that within a second or so, and that is a quote from the transcript, that she heard the pop. And she says that when she went to her, and then her daughter came out, she gets shot, she goes to her daughter, she looks up, and they're gone. This is a very fast event.
Now, the weapon need not be a firearm. It just needs to be a dangerous weapon.
Yeah, but there's no evidence of
A
any
knife.
weapon, Judge.
But it goes to the idea that you would do a home invasion without any dangerous weapon. That you would
But Judge, that's to say every home invasion is armed, okay? And that's to say every robbery is armed. And that just cannot be the law. The law can't be everything's armed unless there's proof that it isn't. The government's got to prove that it is.
So let's assume for the moment that you're right. Sometimes you are.
Occasionally, Judge.
It happens. What's the consequence?
The consequence is that there's a failure of proof on the murder.
Failure of proof with respect to the armed home invasion. for
Yes,
sure.
and well, there's still proof.
There's still a killing.
Yes.
And it's still in the commission of a felony. So that's what I'm asking. Are you saying the consequence is a required finding of not guilty, or are you saying it is a reduction of the felony murder from first to second?
Well, I think that it would be on the home invasion, the armed aspect of the home invasion.
It would be a not guilty, but I don't think we have any. Do we have any home invasion that's not armed?
That's not armed. I don't believe there is, Judge.
Okay, so that's why I'm asking.
Yeah.
That's why I'm asking what the practical consequence would be if you were right.
Well, it'd be not guilty on the
Armed home invasion.
Home invasion.
It'd be an unarmed robbery.
Yes, it would be. Yeah, I guess that would be an attempted unarmed robbery,
Yet what used to be second-degree felony murder.
if in fact malice were proven.
Right.
What used to be.
What used to be.
What used to be. Yes.
What used to be.
Yes.
Lord, but I'm getting confused now. 'cause
You know,
Brown's perspective.
Well,
so-
Judge,
So we're under the old world,
Count me
right?
in on that, but I'm sorry. Judge.
I guess if this is, if you don't get a new trial and you win on this, we could reduce it to unarmed robbery, and in the.
I think it would be an attempted unarmed robbery because I don't think there's any proof that anything was taken.
Still a life felony
Yeah.
in pre-Brown world.
Yes,
That's a second-degree murder.
that's correct. That would be correct, yes. As I think it through, yes. I'm sorry, Judge.
No, you're ahead of me. Go ahead.
All right, so,
If we could turn to merger,
Yeah.
yes,
let me ask you this. Let's assume everything had happened and there had been no shooting. Would there not have been, for certainly, an assault upon Mrs. Finnerty based upon what invariably happened?
simple assault? Misdemeanor assault?
Probably be a yes. I mean, it would certainly have been, I mean, would you agree that if nothing more had happened than they had entered unarmed in the home, would there be invariably an assault upon Mrs. Finnerty in view of what happened with regard to her?
I mean, I don't think that the evidence would support that in the sense of, first of all, there's no evidence that she saw a weapon and therefore was assaulted in that way. And with respect to simple assault, I mean, she says that she goes into the room and falls down. There's no evidence that they really direct anything to her.
Was there fear of imminent harm when two masked men rush through you as you're opening the door?
I think that just goes too far, Judge. I mean, that's not. She never said anything. She never said that I was terrified. That I.
So, I mean, I don't know how she needs to say she said. So they were masked, right?
That was the testimony. Yes.
Yeah. What time of day or night was this?
10:30 at night.
10:30 at night, and she obviously selling drugs. So she opens the door unwittingly to service a customer, and two masked men whisked in. And you don't think that would support evidence that she was in fear?
I just don't think that that's the way the case came out. I don't think that's the way the case was tried. I don't think that would be a fair inference at this point, no.
But don't we have to take I mean, if we use your situation in your first argument, which is we've got a paralyzed husband, a vulnerable older woman, and a teenager.
And a kid.
Right, and don't we have to say, as Justice Gaziano points, in that situation, particularly when they're selling marijuana, they're gonna be frightened when two people rush in? I mean, I don't know if we can have it both ways.
Well, except that I just don't think the evidence, I don't think the government tried it that way. I don't think that it was something that was addressed in the trial.
And just to go back on the evidence, what is her testimony on the guns, on her, again, in the light most favorable to the Commonwealth, that she doesn't see the guns before she hears the pop, pop, or?
Well, that was a little bit confused, Judge, and so, because what she says is that when she, on direct, what she says is, when I ran into the room, my knee hit the coffee table,
I thought she hits the coffee table because she's trying to get away from these guys who are rushing into the room.
She's moving away from them.
Yeah.
Yes, she's moving away from them. She hits the coffee table, and she says that she falls onto one knee. She says that she looks up, and she sees the two men who are pointing guns like that.
Counsel has a note for you.
Okay. Thank you. I'm being pointed out that the judge's instruction that assault is on the husband's daughter, and the jury was told not to consider Judith as an assault victim. So I do think that makes a difference. So if I can, is that the, yeah. So the, on cross-examination.
The judge excludes.
And she said she heard pop, pop.
Judge excludes the entry on, the judge gives an instruction that you can only consider this on for the purposes of merger? I'm getting confused. That doesn't sound plausible.
I don't.
But I believe the judge had taken.
I'm beyond my knowledge here.
I understand. That's why you pay him the big bucks. But,
Exactly.
but I believe that the judge took merger off the table for the jury.
He did.
So
Yes.
the
He
jury-
raised it sua sponte.
So when he's telling them with regard to the assault, he is speaking about the fourth element of armed home invasion, is he not?
I would expect.
Use force or
Judge,
threat
but
imminent use of force.
That seems reasonable to me, Judge, but I cannot answer your
Okay,
question.
so he's not giving the jury a merger instruction. He's giving the jury instruction with
absolutely
regard to
not
the
giving
elements of the offense.
That's correct.
So, I mean, the problem you've got is to deal with Kilbourne. I mean, the Kilbourne, Commonwealth versus Kilbourne, where the court, in an opinion, I believe, written by Justice Cowan, said that there was no substantial likelihood of miscarriage of justice because the jury invariably would have found that there was an assault in view of essentially the undisputed circumstances.
I mean, what we've, in our reply brief, we've pointed out that the facts in Kilburn were a lot more, it was eminently clear that there was, and I can't remember which one it was, because was it Gurney and Kilburn with it? They both involved situations where it was an extended assault, where it was absolutely clear that there were absolutely separate crimes, and I don't think we have that here. We've got a very quick.
But I believe, don't you have? My memory is that viewed in the light most favorable to the Commonwealth, the evidence was that she wouldn't open the door the second time; that she opened it only a small amount.
She said halfway, I think, Judge.
Halfway, and I know there may be a dispute as to, because he had 2 bags when he was found, as to whether a sale went through, but in any event, viewed in the light most favorable to the Commonwealth, the view is that the door was pushed open, forced open.
She didn't,
Said only
the
a-
word force was not used. She said he pushed the door open. She didn't say that she was in any way physically implicated in the door opening. There was no evidence of that whatsoever. She did say, in my memory, is that she said he opened it halfway, or she opened it halfway, and then she declined to make the second sale, and Mr. Booth then opened the door the whole way, stepped back, looked to his side, and the two men came in. And that she then went, and to get back to Judge Kafka's question, she hit her knee, she went onto one knee, she looked up, saw guns and heard pow pow. On cross-examination, what she said was she heard the pow pow as she was falling. So there was some dispute about that, but she, even on cross-examination, she does not say that she looked up.
There's some testimony about what her husband's doing, right? Even though he's basically.
There's not a lot of testimony about what he was doing.
I thought
mean,
there's
she
some.
said she saw him against the wall falling, and that's how she knew he was shot.
There's some explanation of why these guys, instead of just taking the money and running, are actually shooting and killing people.
She said, no, that's, I stand corrected. She said that he tried to throw his walker at
Yeah,
them.
that's what I thought.
Yes,
So then does that suggest there really is a sort of a two-part process to this, that the guns are out, and as there's some resistance here from this guy with the walker?
Well, she's going back towards the husband. There's no indication of when this attempted walker throwing occurred. As she's going towards her husband. I don't,
You need the guns not to be out in some show of force until they're actually firing, right?
She says that they are by the couch, which is well into the room, when the guns are fired.
I understand.
That's what she says, and that's the first time she sees it. She sees the guns, but we don't know when the husband attempted to throw the walker, and we don't even know what that means. I mean, did he just go like this? We don't know.
And does it matter that there are two guns and all the bullets are fired from one gun?
I don't think so, Judge.
Because the Commonwealth's going to get up and say that that's of some significance. You don't think so?
Well, no. I mean, by that theory, my client was in two different joint ventures. He was in a joint venture with one person, for an armed home invasion, and is implicated in the murder. And now he's in a totally different joint venture with somebody else. I don't think that makes sense. These two men were together. They were in the joint venture. My client was in it. I know that this light is blinking crazy here, but
don't worry. Since I've been here, the chief hasn't held anyone to the lights.
Well, I appreciate it.
Get to finish the question.
Okay. This is one joint venture. I mean, I don't think you can separate them in any way that makes any kind of sense. That isn't just, sophistry.
Right, thank you.
Okay. I did not get a chance to discuss 33E, but let me just say that I think that it, when I'm saying this, I'm in no way conceding as to the other arguments, three arguments. What I feel is unusual. I've got three very good arguments. It's unusual. But 33E, if you look at the circumstances here and the piling of inference on inference, I'd suggest that if Your Honors disagree with my substantive positions, that 33E is a very compelling case to be made for it. Thank you.
All right, thank you. Ms. Semmel. Good morning.
Good morning. Maybe it please the court, Catherine Semmel on behalf of the Commonwealth. If I could start with the merger issue. The requirement, of course, is that there be evidence of an assault separate from the assault that resulted in the victim's death, where armed home invasion is a predicate felony. It was not yet addressed in case law at the time of this trial, and the court didn't have the benefit of it.
Can you put the microphone a little closer to you?
Oh, I'm sorry.
Thanks.
The key, I think, to the merger issue is essentially the unit of prosecution for armed home invasion. As Chief Justice Gantz pointed out, paraphrasing, if three people burst into a house and point a gun.
Two burst in.
If two persons burst into a house, point a gun at three people in the house, there are 3 counts of armed home invasion because the unit of prosecution is the person assaulted. I don't think there's any dispute about that. If one of the people then fire the gun, killing one person, that does not negate the other count or counts of armed home invasion that already existed because of the persons assaulted in there. In this case, you could find a lot of other assaults in this case, but I'd like to focus on Judith Finnerty because I think that's the clearest example. And I think that it would be appropriate to say in this instance that Robert and Amy were killed during the course of an armed home invasion against Judith Finnerty, and there would be no merger if the jurors had been instructed in that regard.
That's interesting. What you, and maybe I'm understanding you, is that if there are 2 homicide victims, they could, suppose Ms. Finnerty wasn't involved. Are you saying that there could be 2 separate assaults, one for the one guy that was shot and one for the other guy that wasn't shot, and they feed off of each other?
I think that's possible, but I don't think that's the best argument for why there were separate acts.
I've never heard that theory before.
In this case, only
Maybe there's a reason for that.
because there was only one shooter. I think it is. I think that the second person who was pointing the gun committed an assault that was separate from the act that killed both victims. But again, I don't think that's the best argument. I do think the best argument is that there was a separate assault supporting an armed home invasion against Judith Finnerty. Now, the problem in this case, of course, is that's not what the jurors were instructed. But I would also very strenuously disagree with the defendant's assertion.
Just for a second, so the best theory was there was a separate assault, you say, on Judith Finnerty, but the jury was instructed only on what, on the assault?
The jurors were instructed as follows, and I'm reading from it. In this case, of course, the Commonwealth is claiming that there was the exercise of force against Robert Finnerty and Amy Dumas in the dwelling place. And this was after instructing that there must be either a use of force, a threatened use of force, or an injury. Now, the defense is arguing that the instruction that the judge gave precluded jurors from considering any assault against Judith Finnerty, and I think that's wrong for 2 reasons. The first is he didn't preclude anything. He simply said that the Commonwealth is claiming. And I think I pointed out in my brief instances where the judge very clearly instructed jurors you can and cannot consider X, Y, or Z.
I mean, the problem is the judge didn't instruct at all about merger, and there's no particular reason why any juror would even imagine that we have this rule regarding merger. So it was not anything within that the jury would remotely have considered without instruction from the judge.
I think that is true, and that is why in my brief that I pointed the court to the cases of Kilburn and Gunter. And those are important because there are cases where in armed assault in a dwelling, the jurors were not instructed about any merger analysis, but the court found on the particular facts of that case that there was no substantial likelihood of a miscarriage of justice because there was ample evidence of separate assaults, and based on the particular facts of that case, they found no reasonable possibility, that's not the right standard, but they found no likelihood that jurors would have decided the case differently had they been so instructed.
And am I correct that the defense here did not ask for a merger instruction?
Correct. There was, and this is also a point of some contention in our briefs. The defense did not ask for a merger instruction. The judge actually raised the issue sua sponte, raised and resolved the issue sua sponte, relying on reasoning from other cases to conclude that, in his view, armed home invasion was independent, especially as a matter of law, essentially, and didn't need to be based upon separate acts. That was since disproved in Bell, where the court addressed armed home invasion. In no way did the judge preclude or the parties from joining in the discussion. He in fact pointed out that neither party had contributed to his understanding that it was an unsettled matter of law, but this is what he was deciding. I think it is clear that he would have welcomed input from the parties And certainly he didn't preclude them from discussing it, and certainly it wasn't requested.
So your brother makes an argument that the guns aren't flashed, sort of, we don't have testimony about sort of the guns being flashed in advance. Does that make this a little more difficult? Because it's hard to separate the shooting from the sort of the assault aspects of this.
I think it would make a difference if we were dealing with only one victim, and that's the cases of Scott and Resende that the defense primarily rely on. There was only one victim in that case. There is no witness to the crime. So even though there was suggestion that perhaps there was a struggle and a gunshot that could have supported two separate events, and it was remanded for retrial on that grounds, the court couldn't find that it actually happened. In this case, I don't think there's any requirement for a time disparity for when you're dealing with a separate victim. The unit of prosecution is the victim, is the person assaulted. So you can have three people assaulted simultaneously, and they are separate acts.
But I gather, in this case, were there 2 counts of home invasion or just one?
There was only one count of armed home invasion. It was not specified in the indictment any particular person that it was against. And I do want to note, because I was remiss in my brief, I did want to point you to one footnote, even though I discussed Kilbourne as to the actual facts of that case, as to the actual decision in that case, which concerned whether there were 2 separate acts against the murder victim. I neglected to point out footnote 3 in that brief, which I would just point you to, which discussed the fact that had it been the Commonwealth's theory, the assault on the second person who was present could have been an independent predicate felony. And apparently, in that case, I think the jury was specifically instructed that it had to be the murder victim.
So does Bell diminish or make it more complicated relying on Kilbourne and the other case you just cite? Because Bell sort of confuses that a little bit, doesn't it?
I don't think that Bell, no, I don't think so. I think it followed along with those other cases, and it simply applied it in the instance of armed home invasion. And I think it has been clear, and I don't have the cite for it, but there was a case, Commonwealth versus.
So, but just so I know, to sum up, because there's a separate assault on Judith, and even though the jury is not instructed on it, the evidence is so obvious that there's no substantial likelihood of a miscarriage of justice. Am I summarizing your argument essentially?
That is my position, and I would just point out that similar to the reasoning in Kilbourne, I think that is because Judith was the only witness to what happened in the apartment that night. And I think in entering the convictions that it did, the jury credited her account. And so for that reason, I think that helps you get to the point of assessing what jurors would necessarily have found or not rejected. And if the court disagrees that the evidence is so compelling that there is no substantial likelihood of a miscarriage of justice, then there certainly was sufficient evidence in this case. And at most, it would be a remand for a trial. But I think that Kilbourne and Gunter suggest that the conviction should be just upheld.
If you would turn to the sufficiency of the evidence with regard to knowledge that the others were armed with a dangerous weapon.
I think to address this issue, I really don't think you have to go past the readily inferable point that has been referenced again and again in Massachusetts case law, that it's reasonable to infer that persons going to rob an occupied house where drugs are sold will be armed. And the court said it as recently as last year in Rakes.
I think, though, that we do have an unusual situation where these aren't your typical drug dealers, right? We've got 2 elderly people, one of whom is paralyzed, and a kid, right?
And I don't think, I think that the idea that is inferable that you're going to need some some means of overcoming persons. It's not related to their physical strength necessarily. It could be related to a number of things, such as the fact that drug dealers are often armed, and the fact that there may be some physical limitations of these individuals certainly, if anything, would suggest they were more likely to be armed than people who could physically defend themselves.
What about Mr. Kuhne's argument that theory, as he says, a judicially created inference turns the elements of proof on its head?
I think it's just like many other inferences that we can make, and that it's.
Because didn't we, I mean, if we go to a different area of the law, and we talk about stop and search, we've said that just because you arrest someone for a drug offense, right, the Boston Common cases, you can't infer that this person has a gun. You need a reason to pat frisk somebody.
That's
Just
true.
because you suspect that they're dealing drugs doesn't mean a pat frisk doesn't automatically follow. We've said that that's not a reasonable inference.
That you can't necessarily assume they're armed, but I think this is slightly different in that we're saying that you can infer that the people who are going into this situation are likely to arm themselves in order to deal with these, to overcome any resistance, is the way I think it's been phrased repeatedly, I would note. But in this case, you know, there is some additional evidence in addition to that. The case law also supports the inference that.
What are the, let's just go through all the different types of evidence. So there's this, he's in a room, going in and out of a room where they discuss the robbery, right? And
Where
there's
they
some,
don't, I'm sorry, go ahead.
but why don't you summarize all the different, if we don't want to rely on this inference alone, summarize all the different evidence. I understand that he hangs out with these guys, that one of the guy's girlfriends describes Mr. Hang as having a weapon. I'm just go through all the different evidence because I'd like to see whether there's some intersection between the different pieces.
All right, some of the pieces of evidence are as follows. A couple days before, the defendant was at Fu's house, Fu's apartment, where two things happened, and hopefully I didn't confuse them in my brief. Two things that happened are that Hang mentions that he wants to rob a drug dealer, and the defendant is definitely present for that conversation. Another thing that happens is that Hang.
Is it clear when we go through the transcript that Hang, because Hang is your client is, the defendant is walking in and out of that room, right? Or is that?
There are two separate things.
Go ahead.
Hence the confusion, perhaps. Fu says definitively that Booth is present when Hang mentions wanting to rob a drug dealer. Then there's a second conversation, or a second part, where Hang asked him to call a drug dealer, asked Fu to call a drug dealer with his hand in his pocket, and Fu makes a reference such as, you know, if you have a gun, get out of my house, because that signals to him he has a gun. That second conversation, Fu said that the defendant was in.
I'm sorry, did he say you have a gun, or did he say if you have a gun, get out of my house?
I think if you have a gun, and neither are completely correct in our paraphrasing, I'm sorry. But essentially, if you have a gun, get out of my house.
And did he?
And did he have a gun or get out of the house?
Did he?
I think neither is.
Did he get out of the house?
He did not get out of the house.
And we cut you off before you're going to give us the punchline. Was the defendant present during that conversation?
That was the conversation that Fu said the defendant was definitely present for part of it. He was in and out of the room. He doesn't know if he was present for that specific part of the conversation. So in the light most favorable to the Commonwealth, I think that you could conclude that he was present during that part of the conversation.
How do we?
But what does that prove? I mean, if he had a gun and it's not clear that he did have a gun.
I think the suggestion is not clear, but there's a suggestion that he might have had a gun, that he might have wanted to use a gun, and so forth, that it was a threatening type of gesture, as with a gun. The other aspects are the fact that they were together that day. The court has looked at the fact that there was an opportunity to plan to support the inference that one defendant would have known that the other one was armed. In this case, they were together that night when they went to Wendy's. And according to the defendant's testimony, Hang drove him then to the victim's house. The other evidence of planning is the gloves The two black gloves, one was dropped by Son as he was walking down the stairs. The other one was found on the landing. There was a mixed sample of DNA found on those two matching black gloves.
I've forgotten, what time of year is this? Are they wearing gloves because they're trying to not have
think it
fingerprints?
was
Or are
May.
they wearing gloves
Perhaps
because
Charles
it's
could give
cold?
me a note.
Okay, so it's the summertime.
It was May. Thank you.
Okay, so what do we make of that? These guys are wearing gloves. Does that help any on guns or no?
I think it does help, certainly it certainly suggests that they were going to commit a robbery, that they were going to commit a crime. It may not get you directly to guns, but it's certainly some evidence that something was going to happen that they wouldn't want their fingerprints around for. And there was some DNA evidence which might support the idea that that there was a mixed sample, and both Booth and Son's DNA was consistent with that. There was also the coordinated nature of the arrival of the defendant. First goes, he scouts it.
Before you do that, is there also, one of their girlfriends testifies that she sees her boyfriend, one of the co-defendants with a gun regularly, right?
Correct.
And is there any sense that he's present, the defendant, when that happens in any of these things, or no?
I don't believe so,
Okay.
that he was not present during that particular time, although it certainly suggests that Hang might have made it known that he had a gun in a more general sense. And it was that day that she saw it, but not when Booth was present.
And the size of the weapons, I think one was a .45.
I don't recall the specifics, I'm sorry.
Is there anything about their size which would suggest that if they were carrying them, it would be apparent that they were carrying?
I'm not sure, I'm sorry.
And what are they wearing? Do we know what they're wearing when they're?
They're wearing all black, basically.
And they're
Black
long
hooded
pants and are they
long
wearing
pants
jackets, or what are they wearing?
sweatshirts.
Sweatshirts.
Some kind of, it's described differently, whether they had on like ski masks or hats. But yeah, they were dressed all in black.
I'm more caught up with the chief's question, which is, would the guns be visible depending on what they're wearing? If they're wearing bulky sweatshirts, it's harder to see that if they're wearing T-shirts, right?
Right, they were, yes, and there was evidence that they were wearing sweatshirts, and I'm sorry. I don't know if there was, I know that Judith testified that one gun was larger than the other, but I don't recall I don't recall what the expert said or whether it was discussed, the size of the guns, I'm sorry.
And do we know that the two guns found in the apartment later that night were the guns used?
Well, we know that one of them was a gun used.
Because of the ballistics?
And, yes, and we know that Judith said she saw two guns, so presumably they were the two guns used.
And there was a second gun found near the first? Or
Yes,
found in the same apartment, I
the
believe?
same landing, and slightly different spots around the trash can, yes.
And I assume there are photographs in the record of those guns?
Yes, I'd be happy to obtain those if necessary.
And what was the GSR testimony?
There was on the, I think, right sleeve of Booth's sweatshirt, there was a unique particle found and other particles, but one unique particle which suggested that he had either fired a gun or been in contact with somebody who fired a gun.
What does that tell us?
I think that only primarily tells us that they may have met up after the offense, which goes to the whole coordinated nature of the offense, which I think generally supports the idea that he would know what was happening, including the fact that there were guns. The coordinator of the offense, I think I started to say, was suggested by the fact that he went in, he verified there were people present, verified there were drugs present, and then leaves, comes back, looks back over his shoulder, according to Judith, as the two men come running in, suggesting that he certainly.
And maybe I missed it. Do we have any case law that says that a well-planned, coordinated attack like this would lead to that inference that everybody knows that there's a firearm involved?
Yes, and it's cited in my brief, and I'm not sure I have it handy, Your Honor.
If it's in your brief, that's fine.
It is in my brief. Yes, I don't have it handy.
I mean,
so-
if it's the gang that doesn't shoot straight, we can infer that, but if it's Because this isn't exactly a successful home invasion. This ends up with 2 people being dead. So I'm confused by how well coordinated this is. It's coordinated because he helps get them into the apartment smoothly? That's the
Yes.
well-coordinated part of this?
Yes, and as to what happened inside, yes, it's unclear exactly what happened inside, but certainly the beginning of it is well coordinated, and certainly the defendant played an integral role. The door would not have been opened if Judith didn't know him. He scouted, he determined they had marijuana, and then he knocked again to let his co-defendants in.
And what do we make of the smirk? Is there any significance to the smirk? It appears in the brief. I'm just not sure what we do with the smirk.
It may be consciousness of guilt. It may be suggestion that he understood what was going on. It's some evidence that I think that he was involved.
And could you summarize for me, if we don't find the gun evidence satisfactory, what are the consequences in your view of this?
Well, in my mind, although the court seems to have passed by this, so I know I don't get to ask questions, but in my mind, what would happen is that the judge instructed on armed home invasion and unarmed home invasion, and in my mind, it would reduce it to unarmed home invasion. And I believe, even though it was a life felony, that it's possible that an unarmed home invasion could be either first or second, and that it's possible that it could be second.
Did the unarmed, did he give a second-degree felony murder instruction?
No, he didn't, because I think unarmed home invasion was a life felony.
Life felony.
Say that again, I missed what you just said.
He didn't instruct on second, on the theory that unarmed home invasion was still a life felony.
And is that wrong? Sorry.
I don't think so.
Well, if it was unarmed, wouldn't there have to be a finding of the dangerousness of the?
Yes, which is what, and the judge did instruct on that, which is why I'm saying that I'm not sure if it's possible that.
But if the judge instructed to the jury on that, then that would suggest that the jury need not have found that. The jury didn't reach it, as far as we know, because the
Because they
jury found
convicted.
him guilty of armed home invasion. So we don't know. But I mean, the mere fact that the judge instructed them that they would have to find that the crime itself was, I forget the precise language, but
I forget
sort of
too.
inherently dangerous or something.
Yes.
Does that mean that we can infer what they would have found if the evidence were insufficient that they were armed?
I'm not sure that we could infer what they would have found. No, Your Honor.
What about the fact that the defendant knows the victims, right? He's been in the place before.
Yes.
The fact that the husband has had a couple of strokes, does that lead to this inherent dangerousness that, right? Or is there any relevancy to that? You're breaking into a home with somebody who's, right, he's had a couple of
Fragile.
strokes, he was fragile.
Yeah, yes, I think that's a possibility, yes, Your Honor.
But was there evidence, I mean, he wasn't exactly a family friend, was there evidence that he knew anything more than that Mrs. Finnerty was selling marijuana?
I don't think so. I mean, other than what he would have observed from being in the apartment and the defendant having a walk, and the victim having a walker.
And did he have anything besides a walker? There's not like an air tank or anything like that with this,
There's not like a what, I'm sorry?
Oxygen tank? Is there any of that?
I don't
evidence?
recall any oxygen tank. I only recall them mentioning the walker, which I think Your Honor was asking. Judith might have testified that he picked it up, maybe in an attempt to defend himself from the attack.
All right, thank you.
Thank you very much.